to the courtroom elicits specific responses from the witness, and specific emotions from the jury. For example, in an instance where a lawyer is examining a hostile witness, they will often use language to limit the response of the witness, in order to avoid having the witness present conflicting evidence. In this instance, yes, no questions will be targeted, and questions with room for elaboration, such as WH formation questions, will likely be avoided. In a situation where a lawyer interviews a friendly witness whose testimony could potentially strengthen the story constructed by the lawyer, the opposite may occur where WH questions are targeted to allow for elaboration. Olson, Luchgen Borers, 2013. Lawyers employ specific tactics for both themselves and their witnesses to come off as more or less truthful to the jury and the people of the courtroom. For example, the lawyer may refer to the witness by their first name or a nickname to humanize the witness, or they may speak using slang in order to create less social distance between himself and the courtroom. The lawyer may also avoid using slang and instead use complicated law terminology to set himself apart from the courtroom and define his status. Olson, Luchgen Borers, 2013. The lawyer works in constructing the language of the legal process of the courtroom, and specific witnesses may respond to the lawyer's questions in different ways, eliciting new language tactics and opinions from the jury. For example, witnesses may use direct or indirect speech based on their previous societal experiences, gender differences, socioeconomic differences, or differences in education level. Using particular dialects, slang, or sentence formations could assist in making the witness more or less truthful to the jury. Olson, Luchgen Borers, 2013. Since language can be used to elicit responses in the legal process, the right to an interpreter plays a part in the fairness of the trial. The right to an interpreter is essentially a procedural right that derives from the right to a fair trial. Everyone charged with a criminal offense has the right to certain minimum procedural guarantees, and these include the right to the free assistance of an interpreter whereas he cannot understand or speak the language of the concerned court. Forensic text types: emergency call. In an emergency call, the recipient or emergency operator's ability to extract primarily linguistic information in threatening situations and to come up with the required response in a timely manner is crucial to the successful completion of the call. Emphasis on intonation, voice pitch, and the extent to which there is cooperation between the caller and the recipient at any one time are also very important. In analyzing an emergency call, full cooperation includes frank and timely responses. Urgency plays a role in emergency calls, so hesitations, signs of evasiveness, and incomplete or overly short answers indicate that the caller might be making a false or hoax call. A genuine call has distinctive interlocking and slight overlap of turns. The recipient trusts the caller to provide accurate information, and the caller trusts the recipient to ask only pertinent questions. If the caller uses a rising pitch at the end of every turn, it might represent a lack of commitment. The recipient's use of a rising pitch indicates doubt or desire for clarification. The call ideally moves from nil knowledge on the part of the recipient to a maximum amount of knowledge in a minimum possible period of time. This makes the emergency call unlike any other kind of service encounter, ransom demands, or other threat communication. Threat is a counterpart of a promise and is an important feature in a ransom demand. Ransom demands are also examined to identify between genuine and false threats. An example of a ransom note analysis can be seen in the case of the Lindbergh kidnapping, where the first ransom note, sometimes referred to as the nursery note, stated, "We warn you for making and eating public or for notify the police the child is in gut care, sick." From the sentence, the kidnapper makes the claim that the child is in good hands, but to make such a claim, the note would have to be written before the perpetrator enters the premises. Therefore, the claim is false at the time of writing, since the kidnapper had not even encountered the child when he wrote the note. Kidnappers may write statements that later end up being true, such as, "Your child is being held in a private location," being written ahead of time. Suicide letters. A suicide note is typically brief, concise, and highly propositional with a degree of evasiveness. A credible suicide letter must be making a definite, unequivocal proposition. In a situational context, the proposition of genuine suicide is thematic, directed to the addressee or addressees, and relevant to the relationship between themes. Your suicide notes generally have sentences alluding to the act of killing oneself or the method of suicide that was undertaken. The contents of a suicide note could be intended to make the addressee suffer or feel guilt. Genuine suicide letters are short, typically less than 300 words in length. Extraneous or irrelevant material is often excluded from the text. Death row statements. Death row statements either admit the crime, leaving the witness with an impression of honesty and forthrightness, or deny the crime, leaving the witness with an impression of innocence. They may also denounce witnesses as dishonest, critique law enforcement as corrupt in an attempt to portray innocence, or seek an element of revenge in their last moments. Olson, 2004. Death row statements are within the heavily institutionalized setting of death row prisons. The Forensic Linguistics Institute holds a corpus of these documents and is conducting research on themes. Your social media. Social media statements are often context-specific, and their interpretation can be highly subjective. Forensic application of a selection of stylistic and stylometric techniques in a simulated authorship attribution case involving texts has been done in relation to Facebook. Analysis of social media postings can reveal whether they are illegal, e.g. sex trade, or unethical, e.g. intended to harm, or whether they are not, e.g. simply provocative or free speech. Use of linguistic evidence in legal proceedings. These areas of application have varying degrees of acceptability or reliability within the field. Linguists have provided evidence in trademark and other intellectual property disputes, disputes of meaning and use, author identification, determining who wrote an anonymous text by making comparisons to known writing samples of a suspect, such as threat letters, mobile phone texts, or emails. Forensic stylistics, identifying cases of plagiarism. Voice identification, also known as forensic phonetics, used to determine, through acoustic qualities, if the voice on a tape recorder is that of the defendant. Discourse analysis, the analysis of the structure of written or spoken utterance to determine who is introducing topics or whether a suspect is agreeing to engage in criminal conspiracy. Language analysis. Forensic dialectology, tracing the linguistic history of asylum seekers. Language analysis for the determination of origin. Reconstruction of mobile phone text conversations. Forensic phonetics specialist databases of samples of spoken and written natural language called corpora are now frequently used by forensic linguists. These include corpora of suicide notes, mobile phone texts, police statements, police interview records, and witness statements. They are used to analyze language, understand how it is used, and to reduce the effort needed to identify words that tend to occur near each other. Collocations or collocates. Author identification. The identification of whether a given individual said or wrote something relies on analysis of their idiolect or particular patterns of language use. Vocabulary, collocations, pronunciation, spelling, grammar, etc. The idiolect is a theoretical construct based on the idea that there is linguistic variation at the group level, and hence there may also be linguistic variation at the individual level. William Labov has stated that nobody has found homogeneous data in idiolects, and there are many reasons why it is difficult to provide such evidence. Firstly, language is not an inherited property, but one which is socially acquired, because acquisition is continuous and lifelong. An individual's use of language is always susceptible to variation from a variety of sources, including other speakers, the media, and macro-social changes. Education can have a profoundly homogenizing effect on language use. Research into authorship identification is ongoing. The term authorship attribution is now felt to be too deterministic. The paucity of documents, ransom notes, threatening letters, etc. in most criminal cases in a forensic setting means there is often too little text upon which to base a reliable identification. However, the information provided may be adequate to eliminate a suspect as an author or narrow down an author from a small group of suspects. Authorship measures that analysts use include word length, average number of syllables per word, article frequency, type token ratio, punctuation, both in terms of overall density and syntactic boundaries, and the measurements of hapax legomena, unique words in a text. Statistical approaches include factor analysis, Bayesian statistics, Poisson distribution, multivariate analysis, and discriminant function analysis of function words. The CUSUM cumulative sum method for text analysis has also been developed. CUSUM analysis works even on short texts and relies on the assumption that each speaker has a unique set of habits, thus rendering no significant difference between their speech and writing. Speakers tend to utilize 2 to 3 letter words in a sentence, and their utterances tend to include vowel initial words. In order to carry out the CUSUM test on habits of utilizing 2 to 3 letter words and vowel initial words in a sentential clause, the occurrences of each type of word in the text must be identified and the distribution plotted in each sentence. The CUSUM distribution for these two habits will be compared with the average sentence length of the text. The two sets of values should track each other. Any altered section of the text would show a distinct discrepancy between the values of the two reference points. The tampered section will exhibit a different pattern from the rest of the text. Forensic stylistics. This discipline subjects written or spoken materials, or both, to scientific analysis for determination and measurement of content, meaning speaker identification, or determination of authorship. In identifying plagiarism, one of the earliest cases where forensic stylistics was used to detect plagiarism was the case of Helen Keller's short story, The Frost King, in which the blind American author was accused of plagiarism in 1892. An investigation revealed that The Frost King had been plagiarized from Margaret Canby's Frost Fairies, which had been read to Keller some time earlier. It was found that Keller had made only minute changes to common words and phrases and used less common words to say the same thing, suggesting mere alterations to original ideas. Keller used vast wealth instead of treasure, approximately 230 times less common in the language, but thought instead of concluded, approximately 450 times less common, bade them instead of told them, approximately 30 times less common. Keller used the phrase ever since that time, whilst Canby chose from that time, the latter 50 times more common than the former. Keller also used I cannot imagine, whereas Canby used I do not know. Know is approximately 10 times more common than imagine. Keller relied on a lexis that is less common when compared to Canby's. The Flesh and Flesh Kincaid readability test showed that Canby's text showing more originality compared to Keller's. Canby's text obtained a higher grade on the reading E scale compared to Keller's. The distinctions between Keller and Canby's text are